Hello, Sofa Squad. How is everybody? How's everyone doing? I hope y'all are well. Yeah, come. So, if y'all could drop a number one for me, let me know that you can hear me and the dogs. There you go. Oh, there you go. Get your little thing. There we go. I hope everybody's doing well. Hope everybody had an amazing weekend. Thank you, Professor Funbacks. Thank you, Tori. And how are you, Miss Tori? How are you, Miss Emily? How are you, Miss Indy? Welcome, the three of you, to the stage. Thanks for being here and holding the sofa down. All the boys are here, as you see. Matt has run out to go do some errands, and so it's just me. So just brace yourselves for some doggy noise. Okay, come. There we go. I know. There we go. Let me get them some little treats here. There you go. There you go. Good boys. Okay, go on. Everyone, run along now. Okay, go along now. It's that hour, boys. No. Let's go play somewhere else. Go on. They're kind of like little sharks. I hope y'all are doing well. So, y'all, let's go over some homework first. Okay, tonight we're going to be looking at the hearing from the other day of Stephan Sterns. We're going to watch it. It's like an hour long, I think. Now we'll fast forward the boring parts because I feel like it's unedited footage or whatever. And then now I've seen some other channels do these big phone calls come out, and then Court TV did a version of it that looks more condensed and like down to the like, here's this part. We're gonna watch, it's like a 15-minute video. We'll watch that afterwards. So there's that. Okay, Jake, honey, I know. Hello. Have you seen my father? I don't know where he's at, but he's not here. They're very upset. Um, Jake, no, get off. They wanted to get on the computer thing. And so what we're gonna do is that stop. Yeah, yeah, it's good. And we're gonna see how we can get through it. Okay. Uh, we're in rare form over here, doggy wise. Okay, so let's just say that we've got Lou doing all sorts of things to Jake, and no. Um, so yeah, that's where we're at. So other things going on. First of all, starting the first week of April, somewhere in there, Lori Daybell's trial is going to start. We'll be streaming it. From there on out, within reason, and you'll get where I'm going with this, there's going to basically be trials back to back and overlapping that we've watched for a very long time, followed for a very long time, that I'm going to try and stream and watch it together as much as possible. So that being said, I'm going to be going live a lot. So we are going to be looking for some moderators that want to come help us out over here so that I'm not like stressing Emily and Tori and Indy out. So if you drop me an pardon me, if you drop me an email, reporting live from my sofa at gmail.com if you're interested. And we'll go from there. And I can give me a few days and I'll send you kind of like, the stuff, the criteria, the whatever, like that kind of stuff, we never would call it. So yeah. But like I said, we'll be doing that. I forget, I have to look at the schedule of trials, but it's like Lori's goes, and then very soon, allegedly after that, her next one will go. But I feel like in there, I can't remember if Stephan Sterns is coming up. We also have Brian Koberger. On to the next thing, y'all. Now, we're not going to stream this because it's also going on for Lori Daybell. Karen Reed's trial, secondary trial, Corey Richens. Yes, that's right, Northwest. Thank you. Karen Reed's second trial starts April 1st, allegedly, right? We'll see. I watched that 5-part docuseries these last 2 days and have taught, hey, John, how's it going? And have talked to several people, whatever about it. I'm going to do a video on it, and it's going to be like this. So here's my take or my thing on the Karen Reed situation. So many people wanted me to talk about this. I've not followed it. I know it was like salacious and divided, all this stuff, crazy stuff, whatever. So I was like, you know what? This trial's getting ready to start. Here is a what do you call it? an overview docuseries, right? So we're going to watch it from that perspective, whatever. So I started working, but it's so deep and intricate. So I'm going to do a video on it based on the perspective of like someone like me. You haven't followed the trial. This is an overview. We're going into the secondary trial, right? Because now I am dying to see what happens with the Karen Reed trial the second time. But we're gonna follow other ones because we haven't really followed Karen Reed over here. But I'm still gonna do that and like watch in the background, right? So we'll see. Yeah, so there's that. And then that's that. So yeah, and then Stephan Sterns, Corey Richens. Um, so we'll see. And what else do I want to tell y'all? We have new merch in the thing right here. And it's good. I mean the merch is obviously, but I got my little coffee and a little hot chocolate pack. Okay. So let's just go ahead and say this about what we're getting ready to watch. Trigger warning, okay? I don't know what they'll talk about. I have not watched this hearing yet. I've waited for y'all. And so that's a side note. Emily sent me the other day after our last revisiting evil. What I'm gonna say her name wrong. Dahlia, the one who hired for her boyfriend to get killed, but he wasn't killed. You know who I'm talking about? What's her name again? Dolly or whatever. Emily sent me the links to like all like the interrogations and stuff like that. So we will do that next Tuesday for our revisiting evil. Because I was like, oh my god, I forgot about this one, right? DiPolito, thank you, thank you. Yes, so that will be next week. Because that was just, I feel like we need a palate cleanser after Russell Williams. Okay, we need a palate cleanser, right? Oh my God, and Aaron, thank you. Yes, I was literally working on the script earlier. Sherry Papini is back in court fighting for custody of her kids. Plays out. I was like, I didn't know. So yeah, I'll be doing something on that. Um, so that being said, you live around the corner from, oh my God, so scary. I'm glad you're still here, Samantha. Is Victoria here, right? So yeah, there's so many little things going on, y'all. You don't think she's gonna get it? I would. I mean, I haven't. Obviously, we left off with her husband making that docu series. So it's like, hey, Chrissy, how's it going? So it's like, hey, Casey. Um. So it's like I can't imagine that she would either, but who knows? We'll see, right? Okay. So Stephan Sterns, we're getting ready to watch it. I'm gonna put it up. This is his hearing, and there's that. So trigger warning again, this is Madeline Soto. He's not been convicted yet. He has allegedly unalived her. It's evidence is pretty strong, we'll just say that. So and we're getting on the eve of trial, so this one's a rough one. It's really, really bad, and I'm surprised some other people in and around it are not in jail, but that's just my little opinion. Oh God. Now, let me find y'all over here. Here. Let's go back to here. Now, let me know if you can hear it when I start. Anyway, please hold. Yeah, hold on one second. I got to change my. I don't know how this happens every time. Boom. Boom. Okay, we're gonna do input, microphone, speakers, USB audio device. Okay, now let me go over here. Is it here? Why isn't this playing? Okay, let me think for a second. Why does this do this every time? We did this. We did this. We did this. Right? Is that there? Oh, y'all, it's just muted at the beginning. I can't roll my eyes hard enough at my own self. Good Lord Almighty. I had some grand conspiracy going, like, oh, Lord, something's going on here. There just wasn't any sound at the beginning of it. I mean, I really just can't with myself sometimes. Okay, yeah, that's what it was. Okay, here we go. Now let me share again. What do you got over there? Oh, I was like, what does he have? I mean, I could have just fast forwarded like I did, but now.
Interveners in this party?
We have made our appearance, but I would like to go ahead and formally do that now to the extent.
Okay, can y'all hear it? Drop a 1.
All right. Thanks.
And also, how is my volume
and
above the
pursuant to
thing? Is it too much?
Civil
I'm not
rules
going
of
to talk
procedure,
over it, but I don't want it to be like a
somewhat commonplace
blowout.
procedure. Civil Rule
How about this right here?
1.230. In criminal cases, it's somewhat unusual or less common, almost always more restrictive, and requires leave of court to be permitted to be an intervener and make argument with respect to the defense request. I believe that's going to require an evidentiary hearing.
Okay, cool.
Interveners would have to make a determination as to whether the request is timely, the nature of the intent behind their intervention, whether the court would need to make determinations as to whether that would unduly complicate the case or prejudice the proceedings, and that has not been requested at this point.
Sir, it is my understanding, pursuant to the Lewis case, 1982, Supreme Court case, that we receive essentially automatic intervention for the purpose of opposing closure hearings. If I could refer your honor to that case, specifically case number.
Just side note, it's so creepy seeing him. I mean, we haven't seen him forever. Look at how just withered he looks, and how pale. Ugh, it's just so creepy.
426 Southern 2nd at 1. Media interveners on behalf of as a proxy of the people of the state of Florida for the purpose of intervening, essentially receive automatic the ability to oppose essentially just by walking in. That's been the rule in Florida since 1982, and I do refer your honor to that case.
Wasn't the media a party in that case?
No, sir. They're interveners, as they typically are. Typically, the way this works is the criminal defendant will seek closure, whether over a specific record or over a particular hearing, such as a suppression hearing. And then by law, there has to be a notice to local media, at which point the media then intervenes and receives the right to, at any suppression hearing or any hearing pursuant to that, the right to argue at that suppression hearing.
Sorry, I forgot that. Turn the microphone up
hearing
here.
related to closure. So that's been the policy of the state of Florida since 1982.
Right. So it's your position that the court has no discretion whatsoever to make a determination as to whether intervention is appropriate?
I have never been in a position, I've never had a court even raise that issue. So I do not know the particulars of that issue, Your Honor, because typically it just happens pursuant to Lewis. And so it is the media intervener's position that pursuant to that case and all the cases that have been pursuant to that the media has an immediate right to intervene.
Was it your intention to make argument?
Yes, sir.
All right. Thanks. All right. Well, you're gonna have to provide me a copy of that case and indicate that the court is without discretion to allow argument as a non-party in a criminal case. You have a copy of that case for the court?
I do.
Yeah, they want to just be like, send them out back to old Sparky. Go on and fire it up. We've seen enough. Oh, yeah, let me try the thing, Tux. Hold on.
It's been couched, Your Honor, in the context of standing to intervene.
There we go.
Indeed, you have standing to intervene.
The
This is
attorney
the
talks
Miami Herald case v. Lewis.
Yes, sir.
Yeah, I agree that you have standing to intervene if the court issues an order. I've not been provided with any authority that gives automatic entitlement to intervene in the defense's motion requesting an order from the court. I think the requirement of the rule indicates that you must have notice, and from your pleading, I'm going to make the assumption that the media had notice of today's request. Is that
Yes, we were provided notice, which is why we filed the notice, the motion, the intervention approximately 2 weeks ago, Your Honor, on the docket.
understood?
I can't tell, but the attorney just sounds like super nervous, maybe, or something. I don't know.
Miami Herald Publishing Company v. Lewis, 426 Southern 2nd 1, a 1982 Supreme Court case. In that case, the court ruled that the media had standing to challenge a ruling from the court after the ruling was made. Was there any indication that there was an automatic entitlement to intervene in the initial hearing making that determination?
I believe so. It's either in that or there was other subsequent cases in the late 80s, Barron and others, that said that there has to be notice to local media, at which point the media intervenes.
Do y'all think
by
he also
filing
has a
a
stutter,
notice of
maybe?
intervention
Is that what it
and receives
is?
the right to argue at any pursuant hearing.
Right. You've referenced that precedent. Do you have case law that supports that you can provide?
I do not in front of me, Your Honor. This is a matter I must confess that I have never encountered in arguing these before.
Thank you. I'm going to entertain argument by the parties in the case, and then I will consider your position. Perhaps you can secure some case law that creates an automatic entitlement for the
Oh, RJB's is the
interveners
media guy.
to
Okay.
argue in the initial determination by the court as to closing court proceedings. So, may I have a seat? Thank you.
Yeah, that was like way over my. I zoned out. Do we need to see his ear like that? Please don't show his feet. Let's not have the same cameraman that we got for Lori, right?
Defense State, do you have a position on a non-party intervention?
No.
Defense?
I will leave it to the court's discretion. Generally speaking, I guess we have an objection against the motion that we're filing to ask for them to be precluded in terms of the intervention. Defense did send a notice of hearing to various media outlets, so they were aware.
Thank you. This case was initiated by information on April 11th, 2024, charging Mr. Sterns with 8 counts of sexual battery on a child under the age of 12, capital offenses, 5 counts of sexual battery with a child 12 to 18 in a familial or custodial authority, 7 counts of lewd or lascivious molestation, 40 counts unlawful possession of materials depicting sexual performance by a child, 10 or more images. Counts 1 through 8 are capital offenses. Counts 9 through 13 are punishable by life offenses. Counts 14 through 20 are punishable by life offenses. Counts 20 through 60 are second-degree felony allegations punishable by up to 15 years in prison each, 15 years of supervised probation each, or a $10,000 fine each.
Yeah, he's cooked. Has there been any proof yet of, or any kind of evidence of her being
Appears at the
pregnant, and that
Miami
might be a
Herald Publishing
motive? Why
Company
do we
v.
know?
Lewis, 426 Southern 2nd, 1, a 1982 Florida Supreme Court case. It is the seminal case that discusses requests for closure. The defense has the obligation of proving to the court by a preponderance, meaning a greater weight of the evidence, the necessity for closure. Counsel, do you intend to present argument with respect to your motion?
Yes, Judge. Defense has had pre-marked several defense exhibits. I've given copies to the state as well as to the media, attorney for the media. Defense Exhibit A is a USB flash drive with a PowerPoint that's been previously shown to the state. Defense Exhibit B is a list of articles and videos. Defense Composite Exhibit C is the printout of various news articles. Defense Composite Exhibit D are emails with public records requests. And then I have case law as well, which wasn't pre-marked. I can report now if the court would like that as well. And previously given to the state and the media attorneys.
Thank you.
They've been pre-marked. We think defense would at this time move each of those pre-marked exhibits into evidence as defense's next number exhibit 1 through 4, I believe it'll be.
Thanks. Consider these unopposed.
Thank you, Sherry.
We're waiving objections.
Thank you.
If you could have the Elmo turned on.
Thank you. Do you intend to publish what's going to be defense 1?
Yes, sir.
Cool. Thank you, Chrissy.
Pre-marked exhibits will be received as evidence for purposes of this hearing only.
Are you for real, Riz? That's Anthony Todd's co-counsel?
I believe the overhead projector is.
Oh,
on.
yeah. Megan says he's already setting up his defense at Maddie unalived herself. Imagine, like, I didn't even think about that. Oh, my gosh. This is going to be bad. Oh, my. This is going to be, like, infuriating. Oh, my gosh.
Got the AV controls at defense counsel table. And HDMI.
Yes.
HDMI is plugged in and it's recognizing that it's plugged in.
Please call the AV department. I don't know.
That's right. About
While
the
we do
same
that, I
judge.
can
Oh, my
make
gosh.
additional
Look at the things that
present additional information.
this dude is saying.
In terms of the items that were pre-marked, defense's exhibit, if I could approach one quick to have the correct numbers.
Boone's toilet hooch. Thank you for
This has
adding
printed and presented
your
for the
name always
court,
brings
not
a
the
little
court needs to
laughter to
read
my
them all, but
face.
just
I thank
showing
you
the
for
various
that.
media coverage of this case, various articles from local news stations as well as court TV, crime TV, various news media organizations. Defense has also introduced a listing essentially of those articles that were printed, some of which have YouTube links, which obviously can't be printed for the court. Defense did do a public records request to show the court the public records requests that have been made by various media and interested parties in terms of this case, requesting public records for this case. And though we're not here on Mr. Sterns' other case, I printed the public records request as to each of those in comparison to another homicide that's in Orange County, which involved the death of multiple individuals, to show the court the comparative nature of the public records request and the nature of those items and information that was introduced as the fifth exhibit. I believe it's number 3. And I could provide these to the court. And looking at, and the other ones are Madam Clerk has. And looking at those items that were introduced specifically as to the public records request, the court can see that in terms of Mr. Sterns' 2 individual cases, In doing the public records request, we had to pay an invoice of $56.25 to get just a copy, the printout initially of what was requested by various parties. So in that, the court will see that there have been various news articles or news outlets requesting information.
Ram.
The court can even
That's
see
cute.
within those some of the costs that were associated with them requesting and receiving the items that were requested and ultimately turned over. And in comparison, the case that defense printed additionally was a Chevelle case out of Orange County, which involved the injury and or death of 6 individuals. I believe it's 4 that were deceased and injury to others. And in that case, the state is also seeking the death penalty in that case. The PowerPoint the defense presented or prepared, and if we don't get aviation, if the court is willing to consider it in chambers, essentially just shows podcast interviews, TikTok, Instagram, Facebook groups, Reddit, and on those Reddit platforms shows essentially the full discovery. In this case, you can see links to where the media and various parties have requested all the information, including their screenshots that show this actual hearing being presented on there, links to it, notice of the hearing in terms of this very hearing that we're here for today. There's also, as the court can see, and I would ask the court to make clear for the record that there are also media cameras and media personnel that are present today for the purpose of this hearing. So that will be the information defense will be presenting. If the court wants me to do argument at this time as well, I can do that as well, minus the aviation aspect.
She called the internet out.
State, do you anticipate presenting any evidence in opposition of the defense motion or take any position?
We will take a position, but we just have argument.
Thank you. Ms. Smith, I'm willing to wait until AV gets here if you have a presentation that you wish to present to the court prior to making argument. I don't know why your council table is not registering with our equipment. One suggestion I may have is if the state would be so inclined to allow you to look into their council table, see if that alleviates the issue.
Has anybody seen the movie Hard Candy? Hard Candy. Hey, Dub. Everybody just join in. Hey, Jennifer. Hey, just Joe. Hey, Nirvana. So as we wait for AV, again, this is like the other one, if you do go watch it, because I've talked about it, I'm talking trigger warning, but because it deals with stuff like this, but it's an insane movie with almost like,
Smith?
how would you call the justice in that?
Of course.
It's just, I don't even know how to describe Hard Candy. My mouth was on the floor. Yeah, Donna said it perfectly. I won't say it here, but read Donna's comment. It's the perfect, you know what, revenge movie. There you go. That's exactly it. It's just, it's amazing. Wait, what are we doing here? Okay, never mind. Vigilant justice, yeah. Where they were like, an injustice happens and they went out and took care of business.
All right. So starting
where
first
it's
with
at, Misty. It's an
podcast,
older
Judge, we have
movie.
Podcast showing Mr. Sterns. Defense did a screen recording as to essentially the number of shows and episodes
In true crime
without sound that are pertaining to this case. And on the next slide, it also shows essentially another screen recording of whether it be shows specifically, and then as well as specific podcast episodes that relate to this case, specifically in searching Stephan Sterns' name. Next, we have Madeline Soto, same thing, Judge, showing top results of podcasts that reference her. These podcasts are, as the court knows, podcasts can be from anywhere, but these are some local, international, out of state, various media and networks and outlets. And again, showing top results, specific shows that are doing.
Thank you,
episodes,
Elaine.
As well as specific episodes relating to the case. Next is YouTube. Defense did a couple screen grabs of just searching of the name in terms of what comes up, various news articles that have been turned into videos and clips of varying length, varying views. There are, including the interrogation of Mr. Sterns and the clips that relate to those. There's even, I don't know if the YouTube will open in the courthouse or not, but True Crime Beat, I even did videos pertaining to this very hearing and defense's request to close the pretrial proceedings in the case. The media may or may not let them play. And not that it needs to be played, but just for the court to see that the media has filed responses and YouTube videos in response to our very request to close the courtroom. In that same podcast or YouTube platform, True Crime Beat has an entire playlist that is related to this case with, at the time of the screen grab, over, I believe it's 443 videos at the time that the screen grab was created, which the date and time are in the corner. Additionally, more YouTube links in this case. True Crime with Strategic Eyes is another one of the popular YouTubers who has been blogging about the case and who additionally also has a playlist specifically pertaining to this case. Has already provided videos and done videos dissecting some of the defense's motions to suppress that were filed in this case. Ray Hughes Investigates, another popular YouTube platform, again with a playlist that pertains to this case. Turning to Reddit, this is where a lot of the discovery can be easily accessible. Defense does not have a Reddit account, is not logged in, as can be seen from the upper right-hand corner. This is just a true public search and what is accessible to the public, even without providing any type of identifiable information to request access. And searching Madeline Soto's name, these are the various Reddit groups or Reddit forums that exist in the case. In looking at the one titled, I guess, hashtag or / Madeline Soto, you can see they have a resource where you can literally click a link and get access to the case files in this case. And the screen grab on the bottom right, case files for missing and endangered, is what happens when you click that hyperlink and go in there. Next, we have Maddie Soto Evidence, which is literally just that, a Reddit. Though in discussing the case as well, even as the time of the screen grab of March 11th had been discussed 2 days prior, but has an entire Google Drive with the entire court docket, and includes master list of all the various files in the case. Again, public access that anyone and everyone can click and access. Madeline Soto Evidence, again, pertains to all of the court documents in terms of this case and the accessibility of such. And looking at Jen Soto's, when you search Jen Soto's name on Reddit, some of the groups overlap. However, there is Reddit forums that keeps track literally of the upcoming court dates, including the various court hearing and date that we're here for before, as can be shown by the bottom right screen grab. As I was saying, in searching Jennifer Soto's name, those are the Reddit forums that come up under her name. They cross-reference with Madeline as well. In searching Mr. Sterns' name, again, some of them cross-reference and are similar, are the same forms that come up when searching Madeline or Jennifer, but those are additional forms for that. In searching X, formerly Twitter, these are just various screen grabs showing from initially back a year ago when the case happened, even up until present day, and showing various news outlets that show communications involved in the case, including, as can be seen from the right screen grab, we have Miami in Spanish as early as this year, Orange County, their own Twitter page, providing updates at the time they were doing it, Fox Orlando, again, back in 2024, even as recently as a month ago, talking again about these various hearings that we're here for. We have Puerto Rico, Orlando, New York, English, Spanish channels from 2024, as well as current day 2025. TikTok screen grabs, you can see the next to the heart are essentially the number of likes that a video has gotten. So we have various likes from mere thousands up into the tens of thousands that show from various platforms of varying
Can you
sizes what they
imagine
found.
if she was like, okay, I'm
hashtags
going to show
related to
them
Madeline
like,
or
somebody's
Stephan
live
Sterns.
chat so they can see
Same
just
thing.
how
Or we
whatever.
have up to
And the judge's name was
46.2K, as low as
the
380K.
live chat.
Sorry, 380. And
He
then
was like,
Facebook,
"Yo,
this is hard to see, but the
I'll
groups on the
recuse
left
myself."
are all Facebook groups that
This one
specifically
out.
relate to Madeline Soto, and the groups on the right, the three groups specifically relate to Stephan Sterns. The groups are varying sizes, various names relating to Madeline, finding her, missing, thoughts and different topics of that nature. And then finally is Google searches. If the court wished to, essentially, when you search their names, you can go to the various Google listings and all the articles that pertain to each of them. And then in some of the news articles, I just grabbed a couple. Obviously, we have various different news articles, but Court TV is a popular news station who has an entire page literally related to Stephan Sterns and various proceedings, including as recently as this month, articles being posted as recently as last week, linking to others. And then Paula Neal Mooney has as well. In the podcasting area and some of the Google search, you'll see like Nancy Grace TV and various other media outlets. So that, coupled with the articles that defense was providing, show the various media coverage from local, meaning Central Florida, local within the state of Florida, outside the state, and locations and places that, honestly, I can't tell you exactly where they are, but for it's saying New York, Puerto Rico, or things like that from the news because of the pervasive nature of media and the ability to be anywhere at any time, not necessarily having to give locations as to that. So in terms of presentation of the media information, that's what defense had in terms of PowerPoint.
Like even today, when I was like talking to Matt, and I was talking to him about Karen Reed trial, and then Brian Koberger, and I was like, I'm like, okay, do you know Karen Reed? Mm-mm. Have you heard that? Mm-mm. And he's like, obviously you've been listening to it the last 2 days. Brian Koberger, Idaho 4. He's like, I kind of know it. So that tells you how little, if you're not paying attention to this stuff, they don't know. People, the general public doesn't know about this stuff. It's a very
Defense has certainly
niche
established that there is
amount
a
of people that know.
tremendous amount of media and
Thanks,
social media interest in
Jennifer,
the
for being a
allegations.
member for 11 months.
In Mr. Stern's 2 cases before the court. The Miami Herald case gives the court some guidance as to what factors need to be considered in making a determination before a court may close its proceedings and operate in secret outside of the purview of the public and the media. There is a presumption that all pretrial hearings should be open. Ones, that is a fundamental tenet of the criminal justice system in the United States. Defense, I'd like you to curtail your argument to the considerations that closure is necessary to prevent serious and imminent threat to the administration of justice, that no alternatives
Yep.
exist.
Matt would 100%
Other than a
recognize Sarah
change of
Bone's
venue
name
that
for
would
obvious
protect the
reasons at
defendant's
this
right to a
point.
fair trial, and that
Right.
closure would be
But like he
effective
would have no idea who
protecting the
Stephan
rights
Sterns
of
is,
the
like
accused.
at all.
Obviously, the court must balance the due process right of the accused with unrestricted access to all judicial proceedings. Whenever you're ready.
I provided case law, I believe. Is that, do you have a judge?
I've got a lot of case law.
I handed a packet that had 2 statutes and 3 cases, Rule 2.450, Rule 2.451, and then the 3 cases being Gannett Co. versus DePascal, which is a U.S. Supreme Court case, 99 Supreme Court.
Yeah, and even in
289,
the true
8 from
crime world,
1979,
you
the
have
Miami
like
Herald
different
versus
segments
Lewis
of it
Case,
of like
Florida
some
Supreme
people
Court case,
who
426
only
Southern
follow like
2nd,
say documentaries
from
or
1982,
things like that.
and
Like
then
they're not
Miami
in the
Herald
weeds
Media
like
Company
this,
versus
following
State,
cases
the
as they
3rd DCA
unfold
case
and
here in
whatnot.
Florida, 218 Southern 3rd,
You know what I'm saying? So
406,
they don't. Like, there's gonna be a plethora of people who
so
are like,
looking at
"Who's
those
Lori
3 prongs, which are
Daybell?" And a couple
established
of
by
weeks
the
in the trial
Miami
star,
Herald
it's like,
case,
"Lori, she did what?"
defense would
It's
argue
wild,
that
but to us, we think
the
because we
Closure
follow
is
them day in,
necessary
day
in this case to
out.
prevent serious and
It's just
imminent
different
threat to the
pockets.
administration of justice, because looking at rules 2.450 and 2.451 gives the court the ability to control the conduct of the proceedings before the court, ensuring decorum,
That's
prevent
funny,
distractions, and
Tori.
ensuring the fair administration of justice. So as such, this falls within the court's discretion. The media in their response talks about openness and transparency as being needed to produce a disinclination to testify falsely, when in reality it creates nothing more than an air performance, as if the courtroom is nothing more than a stage. Yes, people have a right to know about what happens in court and the analysis that comes along with that, from internet detectives and analyzers, many of whom aren't even in the state or potentially even looking at the laws that apply specifically within the state of Florida, or the case of this jurisdiction is an entirely different story. So essentially, this prong looks at why, which goes to the jury instructions ultimately that, at trial, the court will be looking to. Potential jurors are supposed to.
Yeah, Casey, I'm the same way where like some of these
they aren't
cases and
supposed
stuff,
to be
it
exposed
stuns me that
through the
people haven't heard of it because they're so
publicizing of the case.
horrible.
Defense isn't requesting
I'm just
a
like,
full
how is
closure
this
of the
not
courtroom.
like?
We're
I thought
specifically
everybody knew
requesting
about
closure as
this.
the pre-trial proceedings. So the three motions to suppress the defense has filed, and we'll be requesting hearing
It's
time
weird.
on, are what we're kind of looking to in terms of that closure. And so in looking at the Gannett case, which is the U.S. Supreme Court case, they talk about, and in that case, they found that the court's decision to close the courtroom was a balancing act, as the court indicated. Nowhere with that case specifically actually dealt with the motion to suppress and the publicity concerning the pretrial suppression hearings in that case, similar to what defense would argue in this case, poses special risk of unfairness.
Thank you for being a member for
because
2 months,
the whole
Ohio
entire purpose of a motion to suppress
And yeah,
is to
it's true
screen
about the
out
sports thing.
evidence that was potentially illegally obtained or is otherwise unreliable in some manner or some fact that should not otherwise be known to the jury. And so so while the court should allow publicity in general instances during the pretrial hearings, like the motion to suppress, that can further influence the public's opinions against Mr. Stern and allow the public to, as well as the potential jury, to have inculpatory information that would otherwise be admissible in the actual trial. And so the danger of the publicity in allowing the admissibility or the publicization of that pretrial suppression hearing makes it difficult to measure what, if any, effects that would have on the actual proceedings. And the Sixth Amendment, which is codified through the 14th Amendment, talks about fairness and the openness of trial itself. Nowhere in the Constitution or common law does it specifically reference or refer to the access to pretrial hearings. So the access to trial, which defense isn't requesting trial be closed, or specifically requesting pretrial hearings, isn't statutorily, constitutionally precluded. We're asking for pretrial. That's not a right that is guaranteed by the rules, by the courts, and that's found in the Gannett case, as well as further found in the Miami Herald Company versus State case, deals with the pretrial publicity. The second prong, Judge, that the court looks to is that no alternatives are available other than change of venue, which would protect Mr. Sterns' right to a fair trial. And looking at that factor, this is pretrial, i.e. before trial. So the entire purpose of this would be in allowing for the closure of the courtrooms during those pretrial proceedings. Hopefully and potentially it will prevent the need to change the venue in this case come actual trial, because of being able to limit and curtail the information that the media has access to, and that there are no other alternatives. As the court saw from the PowerPoint, from the various articles that I provided, the media is, and likely will continue to dissect in every aspect of this case, from the public records request through discovery that was provided via the state, through the public records forum, through any motion and every motion that defense files in this case. And so defense would argue there are no alternative measures that would, other than changing venue, that would preclude or allow for Mr. Sterns to have a fair trial. And finally, closure would be effective in protecting the rights of the accused without being broader than necessary to accomplish this purpose. Again, defense is requesting only the closure of pretrial proceedings, such as motions to suppress in this case, not the closure of the court for the actual trial. And so we're asking for a limited nature of the proceedings being closed or foreclosed. In the cases that defense cited, some dealt with a motion to suppress, one dealt with specifically an Arthur hearing, and one even had a motion to suppress where the hearing itself was closed. However, after a certain amount of time, the access to the transcript was allowed to be gained by the media or those interested parties. So the court was able to, in crafting their order, limit both the time and the duration, the nature, as well as allowed a remedy to allow them to have access at a later point in time. I believe that was the Miami Herald versus State case, in which they dealt with that. So defense would argue that essentially, while pretrial publicity and the fact that there is pretrial publicity in this case, a lot of these cases that form the basis of allowing for the closure of the courtroom was pre a lot of the forms of media that we have now. TikTok, Instagram, Facebook, Reddit, podcasts. A lot of those mediums didn't exist back in the 70s and the 80s when these cases were decided, allowing for the court to allow restriction and closure. The pervasive nature of the internet itself and the exposure makes it to where the pretrial publicity, both the emotional aspect of it, should allow for this court to grant defense's motion to allow for the pretrial closure of certain proceedings subject to whatever limitations the court should impose, such as if the court were to grant closure for motion to suppress, for example, and allow at a certain period of time the allowance or the dissemination of that information, or if the court were to say motion to suppress are not allowed, no access to it, they hear it at trial. So defense would argue that defense meets the three prongs by the preponderance of the evidence, which is the standard that defense had to meet the prongs by as to each of the factors, and the court should grant defense's motion to close the pretrial proceedings.
Thank you, Ms. Smith. State?
Judge, it's the state's position that they haven't shown anything by a preponderance of the evidence. There is massive worldwide coverage of
Thanks,
news
Kate.
these days, but it's very spread out and only deep in very certain puddles. A basement in Sheffield, England may have hit the Reddit, may have hit the YouTube, may have hit all those different sources of news, but they have not shown any nexus to the potential jurors in Osceola County, Florida, and all of the data that they presented to the court. They didn't even show you how many views any of those YouTube videos got, how many upvotes or downvotes any of those Reddit posts got. They haven't shown you how many people viewed any of those news stories, much less how many people in Osceola County jury, Osceola County, Florida, they're eligible to serve in the jury, viewed any of those things. There hasn't been a study conducted by a UCF student, for example, to go out and poll jurors and provide the court with data about the effectiveness of the media coverage in this case in conveying its message. The unfortunate truth that I have found, because as this court knows, I ask every potential jury panel, do you even follow the news? Do you get a newspaper? Do you watch the local news? And it's stunningly small how many people actually follow the news. And in a high profile case that I just did in October up in Orlando, had a whole subreddit and all the YouTube and the sleuths and all the stuff that they presented you. We put 50 jury panels Monday morning, 50 jury on the panel Monday afternoon, Tuesday morning, Tuesday afternoon, and maybe 2, 3, or 5 in each panel of 50 had even heard of the case. And perhaps 2 got excused for cause because of their exposure to the case. I don't say that as evidence. I say that as an anecdotal link
Hear
to
me out.
where's
I'm not
the
familiar with
link
that.
to Osceola County. The YouTube is not just exclusive to Osceola County. WESH isn't exclusive to Osceola County. Reddit certainly is not exclusive to Osceola County. Where's the data about the effectiveness of the message in Osceola County? And it's just not there. And I would submit that without it being there, there's no data for the court to decide that there's a preponderance of evidence shown that this media has been effective in convincing anybody in this county about anything.
Thank you, State. Mr. Minchin, I'm going to invite you to the podium. Mr. Minchin, I've reviewed Miami Herald. I'm not convinced that there's an automatic entitlement to intervention. I think that's still requires leave of court, but I do want to give you an opportunity to proffer the argument that you are intending to make. I will, in a written order, indicate whether the court considered that argument in making its final determination. And I'm going to give the defense an opportunity to respond to both the state and any argument made.
Thank you, Your Honor.
Whenever you're ready.
I was
Thank
able to
you again,
locate some
hear me
authority for that
out.
proposition. However, even within the Lewis case itself, if you look on page number 7, that's head note 6, and then some other case law as well. Quote, the news media has been the public surrogate on the issue of courtroom closure. Therefore, the news media, quote, must be given an opportunity to be heard on the question of closure prior to the court's decision. Also, Chavez versus State says the same thing. Notice and opportunity to be heard prior to closure. Pinnock versus State also, notice and opportunity to be heard. Those are second DCA cases as well. So that is the authority that I'm moving under the Supreme Court's decision that notice and opportunity must be given.
Thank you. When you're ready, argument.
Yes, sir. From the onset, I just wanted to point out that this is, in fact, an evidentiary hearing. And the only evidence that has really been proffered to this point has been that there has been a lot of media coverage of these proceedings. And that's typically the way it works in these cases. Typically, there has been a lot of media coverage, but that has never been sufficient to justify closure. Lewis says, quote, those seeking closure must carry their burden to demonstrate a strict and inescapable necessity of closure, strict and inescapable necessity. And that is an extremely high standard, and that's that phrase, strict and inescapable necessity of closure, that has been used in the case law since then. It is an exceptionally high standard because there is a strong public policy in favor of openness and transparency in the proceedings. Some of those reasons are that it enhances legitimacy, credibility, public trust in the judiciary, protecting the accused rights, keeping judges, prosecutors, and witnesses honest. There's a lengthy quote, I'll summarize it from the Lewis case from the Supreme Court that says, public access to courts, this is quoting, is an important part of the criminal justice system as it promotes the free discussion of governmental affairs by imparting a more complete understanding to the public of the judicial system. Such access gives the assurance that the proceedings were conducted fairly to all concerned. And aside from any beneficial consequences which flow from having open courts, the people have a right to know what is going on. As the Supreme Court has noted repeatedly, the trial is a public event and what transpires in the courtroom is public property. Public access also serves as a check on corrupt practices by exposing the judicial process to public scrutiny and protects the rights of the accused pursuant to their trial. Finally, because participating lawyers, witnesses, and judges know that their conduct will be subject to public scrutiny, it is fair to conclude that they'll be more conscientious in the performance of their roles. Summarizing most of the public policy arguments that we have on that. So the Lewis, you know the three factors, elements rather, they're not factors, they're elements that the defense must prove evidentiarily for it to show strict and inescapable necessity of closure. I'll jump straight to the first element. That is, closure of the proceeding is necessary to prevent a serious and imminent threat to the administration of justice. And there are a couple of arguments that the defense has presented on that point. The first is that inadmissible evidence may arise in the anticipated hearings. But the case law is abundantly clear that whether or not inadmissible evidence may arise in a hearing is wholly irrelevant to the calculus pursuant to Lewis. As the State versus Lugo said, quote, the need to examine evidence for its admissibility is not one of the prongs set forth in Lewis and is not sufficient to justify closure. That's cited in the materials that we provided to your honor. State versus Houston said, quote, the inadmissibility of evidence has no bearing on whether evidence is or is not public record. And in fact, if anything, as Lewis said, whether or not evidence is admissible, in fact, provides a heightened importance of the right of openness. This is what the Supreme Court said in regards to suppression hearings regarding the admissibility of evidence. Quote, although they may prove to be unfounded, these are of importance to the public as well as to the defendants. The searches and interrogations that such hearings evaluate do not take place in the public. The suppression hearing is the only opportunity that the public has to learn about police and prosecutorial conduct. It is important that a decision of the trial judge on a motion to suppress be made on the basis of evidence and argument offered in open court, so that all who care to see or read about it may evaluate for themselves the propriety of the exclusion. So if anything, hearings on admissibility of evidence mitigates toward openness, not against openness pursuant to Lewis. The second argument that the defense has made is that there has been and likely will be publicity. And certainly there's been evidence presented to that. The media, certainly they're the promulgators of that evidence. So
Slow down the cadence just a little bit for the assistance of Madam Court.
thank you, I appreciate it.
Yeah.
I want to be respectful of everybody's time.
I mean, I thought
So
I had
there
him speed
indeed
it
has
up.
been a lot of pre-trial publicity, but that is
I
never
mean-
been a sufficient justification for closure for several reasons. First, Closure based on alleged negative pretrial publicity is essentially impossible in counties of this size. I point you to the case law we cited on that. There are hundreds of thousands of people that living in this county.
It's at
And the
normal
case law is pretty
speed.
clear on that point. Second,
Isn't that
the defendant
crazy?
assumes that the
I
coverage
thought
is
it was,
prejudicial,
too.
which that is something that they must prove, and they have not proven that, just that there's been a lot of it. And third, pretrial publicity is not inherently detrimental to a defendant's Sixth Amendment rights. As the Supreme Court of the United States said in Skellig, which a case that
Right,
the
Wampa
defense
says
presented
it's how I
to you,
did speeches in high
prominence
school,
does
for
not
real.
equal or does not produce prejudice necessarily. And juror impartiality, we have reiterated, does not require ignorance. Jurors are not required to be ignorant of the facts of the issues involved. Scarcely any of those best qualified to serve as jurors will not have formed
He
some
could collab
impression or
with Trisha
opinion as
Paytas.
to the merits of the case. Every case of public interest is almost as a matter of necessity brought to the attention of all intelligent people in the vicinity. And scarcely
Does the court
anyone who
reporter
can
have
be
one of those
found among
talky
those
things?
best
If she
suited for
does,
jurors
she's cooked.
who has not read about it, heard about
She's
it, and
cooked.
who does not have some impression or opinion as to the respect of its merits. A presumption of prejudice is an extreme case, unquote. That's the Skilling case. This quote, pretrial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial, unquote. So all that's been presented this far, as just evidence of pervasive, that has never been enough for those reasons. As to the second element of the test, no alternatives other than a change of venue would protect the defendant's rights to a fair trial. And there has been no evidence presented on this point. The Lewis court presents multiple alternative options that could be available. There was some argument made, but again, this is an evidentiary hearing. Argument of counsel is not sufficient. There could be a continuance, according to Lewis, voir dire, peremptory challenges, admonition of the jury, sequestration. All
Yeah,
of
if
these
he's going to be the
alternatives
one
are
doing the speaking
talked
for the
about in
defense,
Lewis.
for the
These
state
were
and
not
the
even
trial, I'd say
discussed,
the
much
trial
less
lasts maybe 2
evidentiarily
days.
examined.
They'll present the whole case
there's no evidence provided
in the
for them.
morning
So
shift.
without evidence, this element necessarily cannot be satisfied either. And then third, closure would be effective in protecting the rights of the accused while being broader than necessary, being broader than necessary to accomplish its purpose. Under the case law, it's referred to as the narrow tailoring test. And we really can't meaningfully evaluate this because the wholesale closure of all these proceedings is about as non-narrowly tailored as possible. Rather than like a narrowly tailored suit, this is more like it's like a bolt of cloth sitting on the tailor's desk, entirely not narrowly tailored whatsoever. We can't really even meaningfully engage with this element because there's been no evidence presented on it. So also just to frame this in context and summary and closure too, this is not an unprecedented situation. Unfortunately, our state has seen its fair amount of very highly publicized criminal matters. Some of them are mentioned in our papers. Eileen Wuornos, Ted Bundy, Danny Rowland, Casey Anthony, George Zimmerman, Nicholas Cruz, many of whom in fact did seek closure under the Lewis test and they tried and failed because the strict and inescapable necessity of closure pursuant to Lewis and providing strong evidence to overcome and satisfy all those elements is an extremely difficult standard that is very rarely met. So because there has not been evidence to sufficiently justify closure as to all three of those elements, the media interveners ask you to deny the defense motion.
Thank you, Mr. Minchin. Ms. Smith, any additional rebuttal pursuant to the state's argument or potentially Mr. Minchin's intervening argument?
Yes, Judge. In both parties, they talk about empirical data. However, if you look at the Miami Herald versus State case, the third DCA case, it specifically says that no case, the Lewis case, nor does any Florida case suggest that a trial court must consider expert testimony or empirical data. So while they said that has not been presented, that's not necessary in order for the court to rule that closure of a pretrial hearing is necessary to prevent imminent harm. The media interveners talked about, we're assuming that the coverage is negative. Judge, if you look at the articles that were introduced into evidence, the title of the articles in the court re-reviews, the PowerPoint, the heading and the titles of the articles, the podcast, all of that, it implies or is negative in nature. None of it is saying wrongfully accused or anything of that nature in those titles. The media interveners talked about this being a high standard, and the preponderance standard is one of the lowest standards in a criminal courtroom or in a criminal case. It's just more likely than not, so essentially a 51%. So the defense would argue that by preponderance, defense has shown each of the prongs established there is no need for empirical data. Some of the other cases they talked about, I believe in those cases, they were seeking complete closure of the media for all aspects of the proceeding. Again, defense is limiting this to specifically the pretrial proceedings in this case, where different evidentiary items could be found. The Miami Herald case, which the media interveners cite to and talk about a lot, the Florida Supreme Court case, the court did close the courtroom and that was upheld. All the cases that defense provided, the U.S. Supreme Court case, the Florida Supreme Court case, and that third DCA case, all are cases in which it was upheld that the closures that the trial court in those cases did was sufficient and was practical in light of the evidence and the cases that are presented. So defense would argue that based off the evidence and testimony that's been presented, that we have established by preponderance each of the factors or each of the prongs needed to satisfy the court that closure is necessary to prevent that serious and imminent threat, that there are no alternatives necessary or available outside of change of venue, and that the closure itself would be effective in protecting the rights of Mr. Sterns without being broader than necessary to accomplish the purpose. So you ask the court for that.
Thank you, Ms. Smith. All right, the Lewis case requires that the court shall make findings of fact and conclusions of law so that any reviewing court have the benefit of the reasoning in either granting or denying closure. I intend to do that in writing. Ms. Smith, let me ask you, as far as timing of the court's order, are any of these pretrial proceedings currently set for a hearing before the court?
No, Judge, we were going to request hearing time this week, but wanted to give the court that benefit if you wanted to tell us to ask for after a specific date so that we didn't have to go back and reschedule anything.
All right. I anticipate I'll have an order out well in advance of 10 business days. State anything further?
No, Your Honor, thank you.
Defense?
No, Judge.
Thank you. That will conclude our hearing.
Oh, the USC.
It's back over there.
I thought I gave it back. Or not? What do I have? What am I?
You have B, C, and D.
Oh,
Yeah.
So that was all like very technical, very like, whatever. I don't know if they've ruled on this yet. I mean, it is what it is, right? I mean, I get why she's making the argument, and I 100% do. I get it. It is interesting seeing Mr. J and like all these familiar faces. And when he was like, oh, thanks, Elaine, I appreciate it. Yeah, Matt got these little treats or whatever. And so when he gave them to them when they came in, pardon me, what happens is Bo and Lou, the puppies, will take them and drop their treats and then get like territorial over them while the other dogs are eating their treats. And then of course other dogs go to the treats and it starts this whole like just drama. And then Luke gets a treat, holds it in his mouth, and immediately goes and starts badgering the other dogs to get their food from them, even when he still has said treat. It's like what he has. Luke has ADD, whatever you call it for dogs. That's what he has. All things hear me out. And would you be portrayed by Richard Horvitz or oh Lord, I don't even know some of the other ones. I don't even know to say. I'll have to look those names up. But that's really bad. I might be aging myself. I don't know. I know Robert Downey Jr. I don't know the other ones though. What do y'all think? Jeffrey Dean Morgan. I'll have to look them up. Okay, so y'all, real quick, what we're gonna do now is we're gonna listen to the phone call on Court TV and see whatever it is they have. Obviously, it's gonna be a condensed version of it. But we'll see what they say there. Plays out. And then we'll finish talking about it. Okay, hold on.
her body was found in a remote area of Osceola County, Florida. She had been strangled to death.
Can y'all
The
hear it?
investigation led to
Can
her
y'all hear it?
mother's
Sorry.
boyfriend, Stephan Sterns. It also revealed that Sterns had been sexually abusing Madeline for years. Now, Sterns is charged with first-degree murder, capital sexual battery, and possession of child sexual abuse material. He's currently awaiting 2 separate trials. And tonight, we're listening in on newly released jailhouse calls made by defendant Stephan Sterns himself. Get ready. Closing arguments starts right now.
So major trigger warning,
Good
obviously.
evening and welcome to Closing Arguments. I'm Julia Janae, filling in tonight for Vinnie Politan. Thank you for being with us. We're beginning this hour with new developments in a case that we've been following closely here at Court TV since February of last year. That's when 13-year-old Madeline Soto was reported missing. The search for the Florida teen gained national attention. It wasn't until after 5 days that the news was released that no one wanted to hear. It finally broke that Madeline's remains had been discovered. And they were discovered in a remote location at the side of a road near St. Cloud, Florida. Madeline had been strangled, and on top of the horrible news that Madeline was dead, we then learned even more horrifying details about what prosecutors say her life was like while she was alive. Authorities say that the man who killed her was her mother's boyfriend, Stephan Sterns. They also say he had been sexually abusing her for years in the home that she shared with him and her mother. Now, Sterns is charged with murder and dozens of sex crimes against Madeline. And while he waits for 2 separate upcoming trials to begin, he is being housed in the Osceola County Jail in Florida. And he's also doing something else while he's there, not just eating his 3 hots, not just on his cot. He's also making a lot of phone calls. And those jailhouse phone calls, like most, are recorded. They let you know at the beginning that this is a recorded line, but it doesn't stop people from saying things that can sound incriminating. And tonight we have newly released calls between Stephan Sterns and his parents. And I want to start with one clip where this accused killer is talking to his parents, and he's talking about the discovery of Madeline Soto's dead body.
I had gone downstairs for a while, and by the time I realized anything was wrong, it was just far too late. You know, she'd been gone for a while.
Okay.
Just seeing her pale face and blue lips and how ice cold she was, and it's great.
That's gonna stay with you. Yeah,
Yeah, I remember seeing my brother when he had passed away, and that's the last thing I remember seeing of him. And so.
Yeah, you know, it's just, you can tell.
yes, you can. My dad, yeah.
It's just, when they're gone, really, really, truly gone, there's nothing you can do. There's no coming back.
Yeah.
The they he's talking about there when he says they're gone is 13-year-old Madeline Soto. This information is surprising, it's sickening, but it's also really the first time we've heard from this defendant that he was at least around the body of Madeline Soto before it was discovered by authorities. We have someone here with us who can talk about all the details. He's been there to Osceola, Florida. We have Cody Thomas, our field reporter here at Court TV, who's going to help us break these things down. So, Cody, talk to me about these calls, because he's on the phone with his parents, right?
Absolutely, Julia. And there was almost 4 hours of these calls, newly released calls today. And these calls were in the months after he was arrested for this murder, May, June, in that time frame of last year. Now, one of the most important questions that his mother asked him on one of these jail phone calls, she asked him if he was abused growing up. And her line of thinking is because, you know, he's accused of sexually abusing Madeline, that sexual abusers are usually sometimes abused themselves. He kind of reassures her that neither her nor his father did any of that stuff to him growing up. But then she flat out asks him, "Are you attracted to kids?" To which he answered, "Not generally attracted to kids." And then he goes on to kind of backtrack himself on this call with his parents, pretty much saying he doesn't want to incriminate himself. Take a listen to this portion.
Just that, you know, they say that sometimes when you know, like children, that you have been an abused child, and it was intimated that perhaps we had abused you in some way.
No, he has never did. And strictly speaking, I'm not actually into younger people like that. As you know, I don't even like most kids, so it's hard to feel a generalized attraction towards any of them.
Was it just her, or was it other people as well?
I can't get into specific details, but no, it was not a thing with anybody. It was
All right, got it.
but I don't want to get too much into details or
Yeah, I know.
confirm or deny anything officially, anything that could possibly be used against me. I mean, I haven't seen the inside of a courtroom yet, so it'd be kind of stupid to be making anything that could be construed as an admission of guilt.
And Julia, you heard it there, that pause.
Okay, we had to pause here for a second, y'all, and just catch our breath on this one. Okay, now we might get the answers to what I'm about to say here in a minute, but I just have to say it. Okay, so obviously he's alluding to, in my opinion, y'all tell me what you think, that he's kind of I'm not generally attracted or generalized. I don't even like kids. I'm not generalized, attracted to them. So do we think he's going the route of saying there was something special between him and Madeline, and she ended up unaliving herself and he found her dead? Almost like a love story gone wrong or something, like it was a mutual thing. Because here's my thing too, and again, I'm not sure when they said he made these phone calls, all the digital evidence, how, and I get on the phone, right? He's trying to talk his way out of this in this moment, you know what I mean? But how are the parents going to wrap their minds around that evidence? Because if they, and I'm not accusing the parents of being okay with this. I don't know. I've heard just enough of this, right? I don't know if they could scream and yell at him in a minute. I haven't gotten to the whole thing, right? But if they're sitting here saying, oh, well, yeah, okay, pandering that, oh, we found her dead or whatever, how would you ever wrap your mind around, okay, so you were exploiting her on the level of all this stuff on the internet, you know what I'm saying? All that evidence. I don't know a nicer way to say it for here or whatever, but you know what I'm saying? How, I'm just, what? Now, obviously, he is going to try and, how do you say it? Play down his culpability in it. I mean, we wouldn't expect anything less, but this is such a stretch. The evidence that we even know about is so damning. The fact that he's going to trial, minimize, thank you, Northwest, is shocking to me. Yeah, Rise Appendix says she started it. Oh my God. Okay, let's keep going. I just had to get that off my chest.
Yeah.
Assumed to be the names of maybe Madeline or even other minors that he might have mentioned to his parents. But as you were listening, it didn't really sound like a complete no to him being attracted to children or kids. And we also know, he's facing up to or more than 60 plus counts of sexual abuse. And he has a trial coming up for that in May.
I can't believe how calm, how normal they are sounding when they're talking about this, how casual, I guess is the word. But it seems like his mother is struggling with it. She's trying to get some kind of explanation as to why her son could have done this, but maybe even to cover their own bases, make sure they are not being implicated at all. Tell me what else you found in these calls.
So then he ends up mentioning in another portion of these hours of released phone calls, he ends up mentioning Jen Soto, Madeline's mother. Now he talks about in this portion, everyone's suffering due to Madeline being found dead, including himself. He talks about how even goes on to sort of defend Jen Soto in her actions and feelings, in some of those interrogations, pretty much saying that her whole world has been turned upside down because of this. She's lost her daughter now, and, this is just a traumatic experience. Take a listen to this part.
Some of the nurses or officers were talking to each other let's just take the day off today. And I was like, yeah, that's a great idea. You know what, guys? Let's all just take the day off today and come back tomorrow. Well, that would be counterproductive because they want people to suffer. Because suffer. Yeah. Yeah, yeah. If I went home, that'd be, too tempting for me to do something and not go to trial, probably. So they want to make sure that they have their eyes on me at all times. But it's like I wouldn't waste too much energy having any sort of grudge or hurt feelings against her. She's suffering too in her own way. So, well, she lost her daughter. And her whole world was turned upside down too. Yeah. But everyone's world got turned upside down by this. No one is having a good time here.
So, Julie, you heard it there. No one is having a good time here. But as I was listening, I find it odd that he's speaking in this way, considering he's the one currently behind bars charged with her murder. The way he's speaking this way. Exactly.
Correct. And when you hear him talking there, it almost sounds like he's delusional about what situation he's in. Is there anything that you're hearing from him in these calls so far? I know you're still digging through them, and we're going to have more coming up later. But anything where he's showing that he understands the gravity of the situation?
So he ends up talking about potential sentences. And we know in the murder case, not the sex abuse case, but the murder case for Madeline, that he is facing the death penalty. And he actually mentions that to his parents. And he talks in a way that as if he's kind of accepting the very possible reality that he could be sentenced to death. Take a listen.
Murder one is about as bad as it can get, and the death penalty is about as extreme as it can go. I don't even know what method they use down here. Oh, I guess that's not so bad, right? You go to sleep and then you go to heaven.
Go to sleep and go to heaven. Like you said, he's sounding very calm, understanding that he could possibly die due to these crimes. And of course, that trial is set for September of this year, Julia. And again, like you said, we got hours upon hours more of these phone calls to go through. But on Monday night on Vinnie Politan Investigates, we will have a huge extravaganza going through more of these calls, the rest of these calls. So we'll have a whole lot to blow up on Monday about this.
Field reporter Cody Thomas, thank you so much for breaking all of that down. I can't wait to talk about it with our think tank. So let's bring them in. Tonight, we have former senior homicide prosecutor and founder of the Villalona Law Firm, Bernardo Villalona, is with us. Also with us, the chief public defender for Oakland County, Michigan. She represented the Oxford High School shooter. Paulette Lofton is here. And we also have trial attorney, big case Michael Jaffer, with us as well. Thank you all for being here. This case continues to, it seems impossible that it can get sicker as we hear from more about Stephan Sterns, but I think we're there. And Bernardo, let me just start with you, because we're hearing these calls, and I'm gonna start with that first one, where he is saying the explosive thing of him understanding that Madeline was gone, that her lips were blue, that she was pale, she was cold to the touch. What do you think when you hear this statement by itself? What kind of evidence could this be used for?
Well, definitely to show that he had knowledge that she had passed, that she was killed, of her whereabouts. And the question will be, well, how do you know that information? When was it that you saw her? Why didn't you do anything? Why didn't you call 911? So all these questions are questions that the jury's going to have. So it puts a tough question in front of the defense. And that is whether the defendant is going to have to testify in order to explain these questions, explain that conversation that he had over the phone.
Y'all, if he testifies, there's no way. There's no way. Because even that statement right there, now, granted, I know he wasn't saying that in court, but he's saying it to like his parents, of admitting like, oh, hey, I found her body, you know, whatever, regardless of what angle he tried to go. You know, the obvious next question is like, okay, if we suspend belief for a moment and enter into the Stephan Sterns world of logic, which, you know, we've seen this story play out so many times of, oh my God, they were dead and I got nervous and I didn't know what to do and whatever, right? Why on earth would you, all the things he did, dispose of her belongings, pretend to take her to school, dispose of the body, do that? Why? Right? It's like, so why even say that? Why even say that?
phone. So the defense is now in a tough position because now it's fair game in terms of the prosecution being able to use these recorded calls that came from his mouth.
Yeah, Paulette, do you think that he is there creating some kind of defense or at least an excuse in front of his parents that perhaps he did the disposal of the body, but he didn't cause the death? Because in other parts of that call, he says that he wishes he had called police instead of what he did. He wishes he had woken up Jen Soto in that moment.
To create a new narrative. As a defense attorney, jail calls are just the worst to deal with because they're so hard to defend because he's talking to a family member. And even though the recording very often tells them that this is being recorded on the phone, you hear jail phone calls where they're just trying to have a conversation with their parents and sometimes they're exposing their deepest, darkest secrets. And it seems like that's what's happening here. I think he's going to have a real problem because in those first interviews with the news, when he sat down, he said he had absolutely no idea what happened. The last time he saw her was when he dropped her off at school. So now the jury is going to hear this. So what's the truth?
I can see the prosecution comparing these, using them side by side in an opening statement even. Let's talk about the next call. Michael Jafer, there was one where he said we're all suffering here. He talks about Jen, doesn't implicate her at all in this, but he says we're all suffering. This has just turned everyone's life upside down. Do you think the prosecution can get in a call like that? And if they can, how's the jury going to react to it?
I think they absolutely could get in a call like that because I don't think, I think I don't think the prejudicial value overweighs its probative value. But what I also see in these calls, and especially with that calls, I have a theory. I think Stephan Sterns thinks that his parents are both idiots. And I think that he is more so defending himself from stupid statements that might come from his parents. If we recall, his dad was the person who volunteered his hard drive to the police they didn't even know existed. And his mom sent him a letter intimating that, hey, why are you suffering? Other people should also be suffering. And she kind of implicated him in doing it as well. Hey, you always know your customer, right? You're a parent, you know your kid. They know their kid. They clearly probably believe that their kid is a creep, but their kid they believe is a creep. But he maybe was one of those wily, smart creeps who knows how to basically, manipulate them and kind of defending himself from them making stupid statements when he's on a call with them. I don't know, but this guy is a weird, creepy person. He's had a creepy background. His parents are creepy. So I think the prosecutors can bring this in, but it's going to have to be brought in with a whole I think all his jailhouse calls are going to be brought in, except for the ones with his attorneys.
Well, you're right. It is very odd the way he's talking to his parents, and it sounds like they could even be motivated for justice for Madeline if they're asking about other victims, other potential victims. We have to take a
Wow. That is crazy. So, and you heard the part where she was like, maybe he thinks his, or the guy said it, whoever said it, about him thinking his parents are stupid. Listen to, so Stephan's tone of voice, all the way from when we first were introduced to this case, up until now, like in those phone calls, he does have that. I don't know if it's like a narcissist thing or what, I don't know, but it's this tone of voice that they get that's like that they talk down to you. And it's like he's doing that, like, yeah, the death penalty is about as harsh as you can get. I don't know. The way he's talking, it was really, everyone's life's been turned upside down over this. And it's like, why? Like, the level of delusion is so extreme. Hold on. Sorry, y'all. I'm trying to get them to be quiet. Here you go. There you go. Good boy. Where's your brother? Is he up above my head? Oh, no. Okay. What's your brother have? One of the puppies has something that has absolutely upset Bo. This is Bo right here. But yeah, patronizing is a good word. So yeah, that whole thing. And again, there's just no logic to this. Now, clearly he probably wasn't he's obviously not thinking this through. Like he's on the phone in a moment, right? He's not like, well, I said this here and I said that there, whatever. He's probably just talking as they go. So that's the part where it's just because, like the last commentator said, yeah, Griffin says Grizzly True Crime has all the phone calls. Yeah, I think Grizzly, the way they do them, it's like unfiltered. You know what I'm saying? The I forgot what I was saying. I forgot what I was saying. Oh, the last person talking, I forgot what it was. Anyways, it's all horrid, right? I mean, it's just there it is, right? So I think his defense is going to be surely they would not let. I mean, what kind of a defense do you have to this, though? Right? I mean, is he really going to get up there and say that they had a thing going? Like, how could you even hold on? Like, how could you get up there and even say that is your opening? Right? It's like, I mean, just there's no way. Yeah, hold on, y'all. I was on mute, y'all. Sorry. I was having the dogs are doing something, and I was having Matt come get them for a minute while we kind of like wrap things up because I was like, I'm gonna have to keep going on mute because they're barking in the background so much. It's just that time. This is their witching hour, and like from 9 o'clock till midnight, it will be crazy in here. Hey, Dreadhead, how's it going? So I was like, Matt, come get them for a few minutes. I was like, what happens is one of them will get something, like Luke will, and Bo, who's the only one out here now. It absolutely upsets him. Come here. Come here. Good boy. And he will bark and bark and bark. So, anyways, I'm glad y'all love seeing them. Say hey. Oh no, see, we don't want to be touched right now. We're very hyper and turned up. Yeah, I just think it's going to be a disgrace for him to get up there and initiate that some level of like there was just a mutual thing, or that hey, I normally wouldn't fall in love with kids or anything, but Madeline, there's something different there, and she kind of brought it on, and I mean, really, but would we expect anything less? Right? We clearly see that he has. If this is what he's saying on the phone to his parents, and whatnot, there's clearly that level of like delusion, or I can talk my way out, or there also has to be some level, which it surprises me. Like when you think of these cases like this, like surely he has to know. I'm getting ready to potentially go. Well, I'm going to trial. I'm whatever. I'm going to be, probably going to prison, and I'm probably going to lose my life in prison, right? So I often wonder if one of their thought processes is, I have to deny, so I can try and convince the guys in the yard, hey, I wasn't guilty of this. This was this is how this went, to try and like get themselves out of prison justice. It's almost like, I guess the better way to say it, does their mind switch over to prison justice? They've almost accepted that they're going away or getting the death penalty or whatever. So now they're trying to manage prison justice more than anything else. It just makes me curious. Texas denies the only way. Yeah, he could be in survival mode. Mary says, Casey says, Florida don't play. Yeah, Auntie B says, or Auntie Ray, I can't see my glasses. Ray or B, I can't see, but sadly is going to make his lawyers look like fools because they're going to have to give us exactly right. They're going to have to get up there. Like, imagine if that's the story. She and I had something going on, and like she got upset and took her life, or whatever he's going to say, right? Please, hey Amy, how's it going? Vic, I would assume they have him in protective custody, right? Because this is the way I view it. Y'all tell me what you think. When they're in jail, like these people like this, like hardcore charges, and they're in county jails waiting trial, they are way more like that. County jail doesn't want that on their what do you call it, on their watch. Somebody getting to him, right? They want to protect him at all costs to get him to trial. And then once the trial's done, you know what I'm saying? It's it's no. That's just like too, if you remember the please hold, let me get a second. The remember what's it, Jeffrey Dahmer. I remember how like when the things came out, like obviously he was unalived in prison, whatever, but he lived for quite some time. And when people were like he was making jokes about how he killed people and stuff like that, I'm like, how did he live that long? I mean, the things he did was horrendous. Obviously somebody finally got to him, right? But it's like, how did he make it so long? Lauren says he mentioned on the call that he's in protective custody and doesn't socialize with anyone. Give out food in the kitchen, shaped like body parts. That's right. Casey says he would give out food in the kitchen, shaped like body parts. Yeah, I mean, it was like when you heard of like how Jeffrey Dahmer's behavior was in prison, it's shocking how long he lived, right? Where I'm just like, I couldn't. I mean, it blows my mind. But then also, so it's like Anthony Todd, for example. I mean, well, let's look. Speaking of Florida stuff, it's like, is he? I mean, he killed a bunch of kids. Obviously, his own kids, right? So it's like, let's go. Where are we at here? Are we looking at Grant or not? My mind immediately went to Grand Amato. Anthony Todd. News. Sues from prison. So I mean, without doing, there's just no. I mean, you would hear of something, right? You would also think if he got a beat down, you would hear about it. Lauren says, according to Grizzly True Crime, he was trying to get a job in the kitchen, but they didn't think he'd be safe, so they wouldn't let him. Oh, yeah. They probably have him literally. You guys be on lockdown. Look, isn't that cute? That's where he likes to sleep. Bo likes to sleep in that thing right there. He's not so much of like a. Well, no, he did sleep in my like little behind. What do you call behind your knee? Behind your knee, I guess. That's where Bo slept last night. But he usually likes to sleep away from me, like in this thing. Anyways, yeah, Vic says he's not going to last long in prison. I don't think so. I mean, when you're talking like this level of heinous, yeah, I'm surprised with I'm surprised Chris Watts is still up and moving. The nest, the crutch of the joint. Yeah, the Dahmer thing was frustrating, right? You know, they're doing that I forget what the name of the series, y'all correct me here. They're doing the one on Ed Gein. Crook of the knee. Okay. And my dog says, yeah, last night I had Bo behind my knee. No, I'm sorry. Yeah, Bo behind my knee, Luke behind my back, and Jake in my stomach. Oh, now listen. Okay, so speaking. Okay, so Jennifer brings up Casey Anthony, y'all. Okay, so you know how she's on TikTok and she did that whole subreddit thing. Now, and I don't know because I'm like really like not on TikTok as much now or whatever, but there's a girl on TikTok who says that Casey is suing her for defamation, and now it's like like numerous people are coming out talking about. I heard from Casey's lawyers and blah 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 blah. You know, and it's like, was this true or not, or are people just trying to get attention, right? But I almost think that Casey, her whole modus operandi was to put herself out there and then start filing lawsuits against people to make money. Now, I don't know if you can truly make money, like, and I'm talking long-term money, like, because it would take a while if you sued somebody, right? Yeah, I'm Vamp. I'm surprised that nobody's taking care of Casey Anthony. Again, very surprised. Farmer, thank you very much. And Farmer asked, do y'all think Jen will testify in his defense? Somebody said earlier, and correct me if I'm wrong, that she's supposed to testify for the state, but I could be wrong. And also, do y'all remember the name of the immunity that she has? Because Casey Anthony, she's out of bars, she's doing stuff. Obviously, she's breaking up marriages, she's going to the gym. I mean, you just know that people whisper and talk all the time. Limited transactional. Okay, thank you, Northwest. Oh, Nirvana Fairy, you've been a member for 13 months. I appreciate that. And Charlie Hunnam is playing Ed Gein, or Gein, however you say it, on Netflix. When's it come out? Let's look it up. I can't wait to see it. You know, that's where the kind of one of the people came from for Chainsaw Massacre. Monster. Okay. Well, when does it come out? It's gonna be good, y'all. Hold on, let's see here. I mean, I can't get a straight up Google answer. It's just articles about it. Does anybody know? I mean, come on now, people. It's like, well, let's just look up the news. Let me see if anybody said it. I'm not seeing it, so we'll return to that later. So, okay, so y'all, now that we have everybody in here, let me see my little announcements that I did earlier too. Okay, so starting like first week of April, we're going to be doing like trials back to back to back and some overlapping that we've been following for a really long time. If anybody is interested in helping mod, because I'll be streaming a lot during the daytime, like, you know, like for Lori Daybell's first one we're watching, right? We'll be doing it from this channel. So if anybody's interested in helping mod, just email me reportinglive@gmail.com. I'll get to it hopefully in the next couple of days, and I'll send you like kind of like a, hey, this is how the Sofa Squad goes, or, you know, hours, or, you know, like kind of like the gist of like how we roll, that type thing, right? And then we'll see if everybody, you know, who jives and all that kind of stuff, whether it's whatever. because yeah, starting then it's going to be like trial after trial after trial, and some, like I said, some overlapping. And so Casey asked, Paul, are you coming to the Karen Reed trial? So I'm not going to stream the trial because it's going on the same time as Daybell's. However, I just watched the 5-part docuseries, and that's the most I have researched that case. So I am going to make a video, like one of my typical reaction videos to the docuseries. I have, of course, now from that been looking at different parts of testimony and stuff like that. So yeah, I would say that my overview of it, it's obviously not going to be as in-depth. I mean, that case has so many layers, but it'll be like here's where we're at for the trial, the second trial that starts in a couple of weeks, or in a week or so, or whatever it is now. So yeah. And if like major stuff comes about or whatever, then, yeah, for sure. Yeah, from what I could see, the docuseries was like, I mean, I'm talking a very broad overview of it. Lori Daybell's a trial coming up in the first week of April. We're going to be streaming. Lori Daybell is going to be facing 2 trials back to back. And Mandy, thank you for that. And yes, we're going to do Donald Adelson trial, Corey Richens. Oh yeah, and that's right. Thank you very much, Shannon. We're going to be doing for our Tuesday night Revisiting Evil is Dahlia DiPolito, that case. So if you want to look it up or whatever, that's what we'll be doing then. We'll see if we get through it. I mean, there's a couple of videos that we're going to go through. I figure, like I said at the beginning, we need like a palate cleanser from Russell Williams and Stephan Sterns and stuff like that. This one will have that level of absurdity in it. And technically nobody was murdered, right? She just tried to get her husband or her dude murdered. So, but it's still obviously nonetheless, like, there's victims in it, but not like, these here. And yeah, we'll be covering Brian Koberger's. There's so many trials that are coming to a conclusion. It's crazy. So yeah, so that's why, I was gonna like, okay, if anybody's not interested in, jumping on the mod team. Yeah, Culinary asked a good question. Hold on. I'm sorry. And I don't know the answer to it, but I wonder if the Karen Reed case will happen before the one for that cop from the same department's trial. I'm not sure, but I think that one is going up in 2025. And I am very interested I would probably like to, if possible, follow that one, because that is horrifying. And knowing, and I can't remember the name, what's her name? Sandra, a young victim in that case from the same department, all intertwined as the people who are, handled the Karen Reed stuff. Yeah, Matthew Farwell is the cop. They're setting a date of April 15th. Oh my gosh. So I wonder if Karen Reed will wrap up before then. Can you imagine those two things going on at the same time? That's Sandra Birchmore. Thank you. Yeah, so if you're interested in the Karen Reed trial and like you're not like 100% sure about it, you're going to also want to look up Sandra Birchmore. So absolutely. Wait, that trial won't be streamed. Oh, it's a federal case, isn't it? That's right. Yeah, that's one. With the cop kill, she was expecting his baby. So yeah. So it's gonna be crazy. So, but y'all, look, I'm gonna run, because I gotta go to bed and start off the week. Thank you, Emily. Thank you, Indy. Thank you, Tori, for holding the sofa down and helping us all get along. Thank you, everybody, for hanging out and watching all the stuff that we watched tonight. Thank you for putting up with puppy bark. So they're coming to say goodbye. You want to say bye? They say no, we want our treats. But that's it. Thank y'all. I have my little update thoughts on Lori's last hearing tomorrow morning, and Tuesday night we'll be meeting to go over the Dahlia thing, interviews and stuff like that. So that's it. I hope y'all have a wonderful evening. I love y'all, and have a good evening. Thank you, everybody. Bye.